Good afternoon and welcome to Let's Talk Justice. Today is Tuesday, February 21st, and we are coming to the close of the second month of 2023. Time passing fast. Jade?
Passing is the term that you're using. Flying. Speeding.
Moving full speed ahead, huh?
Absolutely.
All right, I'm Michael Jackson, Executive Director of Jamaicans for Justice.
And I'm Jade Williams, the Policy and Advocacy Specialist.
No, we said at the start of February that we're doing a little bit of a public education, if you will, around Black History Month. And I indicated that the position of the Secretariat at JFJ, and they warned us completely where this is concerned, that the staff of JFJ, we celebrate Black history every single day. But we believed and felt it important that the Jamaican population understands a little bit more about our history, the implications and the influence of that history on our human rights, and how the legislation and the policy development of the country, particularly Jamaica, but certainly across the English-speaking Caribbean islands, would have been influenced by our experiences of our colonial past. And I know some of our Pan-Africanists would say that our history as Blacks, it does not, or it did not start with slavery, but rather we're kings and queens when we look at our contribution to development. Yes?
Yes. So with that in mind, our topic for today is decolonizing the Constitution. We would be talking about assessing the retention we're really talking about savings clauses and how they allow us to retain what are provisions that are pre-independence, and how that is currently affecting the way that us as citizens are able to take up our rights.
So before we get into our guest.
Who are our guests?
Our guest, Patrick Layla, close family member of ours, policy and advocacy officer with Jamaica Aid Support for Almost Jamaicans for Justice, Jamaica Aid Support. I'm not giving away your position, Jane. Jamaica Aid Support for Life, as well as Nicoy Wilson, close friend and colleague of ours, policy and advocacy manager at Equality for All Foundation. But just to point out that, as we stated, we were once a colony of the United Kingdom. And as we move towards decolonization, which is gaining independence, which we got August 6, 1962, what that meant was that there was a transitionary period with adopting our constitution. So there were two clauses, the general savings clauses, as well as the special savings clauses. Correct me if I'm wrong here. Speaking off the top of my head, we have no notes at this time. The general provisions really speak to all the laws that were under the United Kingdom. They transferred once we adopted our constitution. Some of them are really, really bad laws. But some are very good laws in governing our country. And we got our written constitution, which is what is causing much of a debate when we talk about constitutional reform and that committee. And we soon talk about the Vale Royal talks shortly. And then the special savings clauses, as Jade mentioned earlier, these are the clauses that I would say time stuck, unfortunately. And though human rights would have developed certainly in the country, we see where it has implications for things such as abortion, I believe, death penalty, buggery. What else? There's a fourth.
It is, I think, the extension of anti-discrimination protections as well.
So, important things to discuss. But before we get into it, Jade, Vale Royal talks finally happened. I listened to Beyond the Headlines yesterday evening with Dion, and I think she squealed like a young girl with excitement when she said the Vale Royal talks finally happened, and it involved the Prime Minister, the leader of the opposition, Senator Scott Motley, Minister Malahoo Fort, and other members across both political parties. We do not yet know the nature of the discussions, what agreements would have come out of it, the consensus or the areas that are still a sticking point between the two political parties. But it was hosted, I believe, by the Jamaica Council of Churches. So it's something to watch over the next couple of days in terms of what those areas of consensus are, and whether or not the opposition would now see it fit to name his two committee members to the Constitutional Reform Committee. So that was an area that came out of last week.
Yes.
Anything else jumped out at you?
From out of last week, I thought we were leaving this to the end of
You're
the show.
really still tired, you know. By the way, Jade is currently leading on drafting our position as we review the NIDS regulations, which becomes due today. So for those who have an opinion on the matter, there's still time for you to make that submission. But there was a video last week, Jade, at a high school in Kingston.
Yes.
It brought tears to my eyes for two reasons. It is now on social media to indicate that the boy who was seen in the video being kicked and abused by two others, apparently he is autistic. And even before knowing that, it was shocking because there was such bravado with the one who was doing the kicking that you ask the question, what is happening with our youngsters? How can we rescue them from early? Just how he was moving around, I don't think this was his first rodeo, unfortunately. You know, we're smiling about it, but I'm not smiling because it's funny. I'm amusing in any way because it's great discomfort watching it.
Yeah, I think that there has to be a discussion around examining what is fueling the violence in our students. Yes. I think that has been a neglected part of the conversation in the response to violence in schools.
Yeah.
Because what would compel someone to treat another person in that manner? I think it's important that we probe what that influence is. Yeah.
All right, so as we get into today's topic, you have a Did You Know?
Yes, I do. So our Did You Know for this week is topical, I would say. It's a bit related. So it references our Obia Act. So our Obia Act from 1898, I want us to take note of that commencement date, is still in force. It makes it illegal for a person to practice obia, and obia under the act is defined as a fraudulent or unlawful activity used for gain or for the purpose of frightening another person through the use of occult means or claiming to have a supernatural power, supernatural knowledge. One thing as we talk about decolonizing our constitution, this is one of those provisions that comes from our colonial history of anti-blackness and anti-Africanness.
And the use of these laws to suppress black people.
Yes, and to suppress our culture as well.
But beyond culture though, Jade, how this law came into being was to suppress the rebellions of the blacks.
Yes.
You know, I urge persons, Taki from St. Mary, I come from St. Mary, and I used to live down that side. So we're very well versed on the Taki history, Maroon history, and so on. So I just want people to put these things in perspective, that there's so many bad laws on our books. And have to go in my patwa. I don't know if you hug up. We need to get rid of it. And any day the Minister Malahoo Fort is ready, I tell you, I'm willing to sit down by whatever offices to say, listen, get rid of that 1, 2, 3, 4 and go right down the list, because too many are still on our books for comfort.
And, it reminds me of a quote from Lord Nichols. I actually looked it up just before we started, from the case of Boyce and Joseph and the Queen, 2004 case, Privy Council case, that you can look it up if you're interested. But in the case, he opined about savings law clauses and stated that it seems to be a tool for those persons responsible for ensuring that the necessary measures are in place for those to protect themselves and have full measure of protection against the execution of a violation of their rights.
Yes.
That the savings law clauses seems to be used as an excuse to prevent that kind of protection being put into place.
Yeah, agreed.
Yeah.
All right, we have our guest online now. We have Nicoy Wilson.
Hi.
All right. Hi, Nicoy. Patrick is late, but we will send him a little facetious text while we're on. Thank you so much for joining. We appreciate it, and we wished you were here in person with us. This time here with Jade. So, Nicoy, can you just start in terms of what equality spur perspective is around the savings law clauses. Just a general opening as we get into some of the specifics.
Okay, so at Equality for All Foundation, we represent the LGBT community in Jamaica, and when it comes on to the savings law clauses, it's problematic for us because it prevents us from challenging certain laws, which in effect perpetuate the discrimination and stigma faced by the community.
All right. Go ahead.
I don't know if you could give us a little bit more for, because I think a lot of our viewers are ignorant as to what kind of effect it could possibly have. So I don't know if you could give us a little bit more detail as to what you would like to see changed. Nicole? I seem to have some trouble connecting with him. Is our other guest online? Patrick, are you there?
Yes, I am. I'm here. Afternoon.
Good afternoon, Mr. Layla. You know that you have some demerit points for being late, but we will talk off air.
Okay, ma'am.
Welcome to the show.
I was following the road traffic act. I was driving and forgot my hands-free kit, so I refused to come on.
The police, they're not listening in. But anyway, what is the perspective of Jamaica Aid Support for Life when it comes to savings law clauses?
Well, we believe that the parliamentarians have positioned saving laws clauses as something that tie their hands. And the reality is, it is not. We believe that if there is the political will, if there is really the desire to provide certain protections that are missing from the Constitution from all classes of Jamaicans, then the parliamentarians just need to do what they are supposed to do. The parliament is the body that has the power to override any such clauses, and therefore they just need to do what they need to do in Parliament, take the necessary action, get the necessary number of votes, and amend the Constitution and remove those clauses. It is not beyond them to do it. So this position as if they, because we cannot be a sovereign nation and have some clauses that are just there in perpetuity and nobody can touch them. The parliament can act and remove those, and that is what they have failed to do. So when they use that as an excuse to say we can't touch this because of the savings law clause, the parliament can.
Is it a convenient excuse, you think, because of the controversial areas? So we spoke earlier, Jade and I, when we started, in explaining to our listeners that the savings law clause, it has implications for abortion, which I don't think my right to my privacy and whatever decisions I want to take to my body should have implications, or the parliament governing that. My personal view here: abortion, buggery, death penalty. You think it's a convenient excuse because these issues are all controversial matters?
I 100% agree with that proposition. I think that is indeed the case. When you look at the savings law clause, and I'm glad you explained to the listeners earlier what they cover, because really if you look at it, it's a wide range of, I don't want to say sexual offenses, but sex-related offenses, like abortion, as you mentioned. Outside of the death penalty. It's predominantly those very sensitive areas that no parliamentarian wants to go down as the person who made such an amendment. So the easiest way to get out of it is just to say, well, you know, because of the savings law clause, we can't do anything about that.
1 second,
so it's really
Patrick.
all those sensitive things that they don't want to touch.
All right, thank you. We have to take a break, and then when we return, we pick up with Nicole, who was explaining earlier the implications for the LGBT community.
Welcome back to Let's Talk Justice. We're talking today about savings law clauses, and before the break, I'm just going to discard Patrick for a second. Before the break, we were speaking to Patrick Layla from Jamaica Aid Support for Life, but I just wanted to pick up with Nicole Wilson from Equality for All Foundation, where he was giving us some idea of what sort of changes the LGBTQ community would be looking to see with the removal of the savings law clauses. Nikoi?
Right. So as you have mentioned earlier in your show, the savings law clause affects sexual offences, which includes buggery, which is found on the Offences Against the Person Act. Now, when it comes down to the buggery law in and of itself, it violates LGBT people's rights to privacy, to equality before the law and freedom of expression. But it also affects women and children disproportionately as well. So when you look at the statistics, between 2016 and 2020, 80% of the cases, which was 286 reports of buggery, the victims were children. And only about 4% of those cases involved adult men as victims. And because the JCF doesn't necessarily, provide information as it relates to consent, we don't know if these cases were actually cases where adult men were consenting to sexual activity. So this is how the law really affects us. And then just to delve a little deeper, when it comes down to classification of buggery as well, the difference between buggery and rape. Buggery, there's a maximum stipulation in the law of 10 years, and when that's compared to the minimum that the court usually starts with, which is 15 for rape, you can see there's a disparity in the sentences for those two offences. And so we want to see not only the removal of the buggery law as it is, but a clause that includes forced buggery as rape, so that persons who are raped in that way can seek legal redress and get the similar sentences and because it is would be considered rape. So that's kind of one of the implications of the savings law clause, and it also prevents us from bringing a case in the court to say that, hey, this law affects my life, my right to privacy, my right to freedom of expression, my right to equality before the law. So that's really how it affects the LGBT community and other vulnerable groups.
Okay, so just for clarity, Nikoi, so you're saying that if you wanted to challenge the law in like you would do a normal constitutional challenge, you wouldn't be able to because of the savings law clause.
Right. The court would say it cannot rule on it because of what our constitution says. And currently there is a challenge in the court by Maurice Tomlinson, where there's basically an argument that because of the introduction of the sex registry and inclusion of those individuals who would have been convicted of buggery, that would suggest a change in the law in and of itself, and so therefore it can be challenged. But we are waiting the court, the trial for that matter.
Yes.
Okay, thank you.
And we also saw the recent ruling in Barbados, it was.
Yes.
With that constitutional challenge, which found some victory, and the buggery law is to be struck there.
I think we also saw something similar in Trinidad a few years ago.
But there are two things I want to point out to the listeners, and then I will ask Patrick to pick up. The first thing is that, and I want to be very clear to all the men who are listening here, that the Buggery Act is not only criminalizing, if you will, members of the LGBTQ population or community, but men, heterosexual men and couples who engage in anal sex, as many of you do, though you may not be willing to admit it publicly because of the stigma surrounding the act. But I want to be very clear that it also has implications, because the government is basically coming into your bedroom to say that this consensual activity that you're carrying on with your partner, it is criminalized in law. That's the first thing I want to pick up, because it does not only have implications for gay men, but any individual who partake in anal sex. All right? The second thing to note is that, Patrick, and I will go to you here, is that there is the perception perhaps that to make amendments to sexual intercourse in law under the Sexual Offences Act, which will have implications for rape, where we want to broaden it to include anal sex, forced anal sex in this particular regard, that automatically means that the Buggery law has to be struck. Though we agree with it, We see in other jurisdictions, I think Barbados made some amendments before that constitutional challenge. Bahamas, which actually criminalizes buggery for up to 20 years. And there's one other country off the top of my head, I can't remember. But what is the view of JASL when it comes to rape and buggery, especially of our children, as Nicole was articulating earlier? What is JASL's position? And
just before Patrick responds, I just want to let the listeners know that as it's constructed, buggery does not consider consent at all. So regardless of whether or not you consent to the act, it is criminalized. Patrick, go ahead.
All right. Thanks for that plug, Jade. And I'm glad how yourself and Michael laid it out, because I think we have a wide misconception in Jamaica that buggery is somewhat specific to gay people. And we have to understand that any anal penetration, regardless of who it is. But for us, the issue of rape is a very serious sexual offense that should cover all the different forms of violation that one may commit against, whether male, female, whether it be a child or an adult. The reality is, where the law is now, it does not provide protections for men. So there's a gender bias in the law where rape is concerned, where only a woman can be raped. So all the other sexual violations that may be committed against the boy child or adult men, while we are not saying that there is no provision in law for that, there is no serious provision that treats it as a serious offense as rape. So
you have the grievous sexual assault, Patrick.
Right. You have the grievous, so you have the buggery, which is the next highest in terms of penalty. You have the grievous sexual assault, and you have, which can come with anything from a probation, from someone being put on probation to up to maybe maximum 5, if I remember well. So the reality is, men, there's no protection for men and boys when it comes to rape, and we believe that there has to be that change in the law where sexual intercourse is more broadly defined so that we can cover any. When you look at the UK, so for example, even outside of men, we still don't have proper coverage for women, because the same will apply if a rapist decides to penetrate the anus of a female. He then could not be charged for rape in Jamaica. The same will apply if he forces that female to perform oral sex on him, whether male or female. The same will apply. It's not rape. When you look at legislation in the UK, all of that will be covered under rape, whether it is forcing to perform oral sex, anal penetration, vaginal penetration. And it all comes back to us tiptoeing around the issue of buggery and homosexuality, which creates that fear. Yes. But as Nicole said, as it relates to the savings law clauses and the fact that the court will not entertain challenges to the law based on that clause, it goes back to the point I made earlier. The people who can make that change are the parliamentarians, because the court adjudicates based on what is in legislation or the Constitution.
And so just to pick up here, Patrick, because we have to switch to Nicoy to get his view on something, because I want to shift. The Joint Select Committee met in 2018. They submitted their report, and when it came to redefining rape in law, they said that they're going to be doing a referendum. I laugh, but anyway, serious issue. If you call it passing the buck was a thing for parliamentarians, such disappointment in that regard. But Nicoy, from your perspective, JFLAG, Equality for All Foundation, is there an opinion on abortion that you can share publicly?
At the moment, no.
Okay. And Patrick, I don't suspect you'll be able to articulate that either.
No, I do not have a position to share at this time.
Okay, all right. All right. Any closing remarks? Let me start with you, Nicoy, as we wrap up.
Yes, I just wanted to say that on the matter of parliamentarians, having the power, they surely do have the power to make the change that is necessary, that is repealing the buggery law and, bringing into being comprehensive anti-discrimination legislation. I think in 2011, when these clauses were put into the Constitution, that, probably the thinking of the legislature at the time was that these are things that are sacred to Jamaican society. But I think it's time now to recognize that these things are holding us back, and that the changes that are necessary need to be made, swiftly.
All right, thank you so much, Nicole. Patrick, your final words?
I just want to say that it is foolhardy in 2023, in this day, for us to sit and say that our courts cannot act or the Parliament refuses to act because some clause is in the Constitution since we got it from the UK. My word. Some people may say otherwise. That's right. See, we have to get rid of that. And I think that if we are serious about human rights and the protections of all our citizens, then this is something that must be acted upon with expedience, because we cannot continue to operate in an environment where certain segments of the society get disregarded and their rights are not respected.
All right, thank you so much to you both. Again, I hope we buck up again soon. That was Patrick Layla, Policy and Advocacy Officer, Jamaica AIDS Support for Life. Nicole Wilson, Policy and Advocacy Manager, Equality for All Foundation. Thank you again, gentlemen. Before we go to the break, I want to be very clear where JFJ's position is on abortion rights. We believe that the woman has a full autonomy to choose.
Absolutely.
And we believe, at minimum, the law should recognize that in circumstances of rape, at minimum, yes, and for medical purposes, abortion should be so permitted. And obviously our position on death penalty is well known and ventilated, so I don't have to go back through that.
So I think our position on the definition of sexual intercourse is also well documented,
yes,
and Googleable.
All right. So we take a break, and then on the other side we pick up. Welcome back to Let's Talk Justice with Jamaicans for Justice. I'm Michael Jackson, Executive Director.
And I'm Jade Williams, Policy and Advocacy Specialist.
No, we just had a very good discussion with Equality for All Foundation and Jamaica AIDS Support for Life on some of those laws that we have retained post-independence, and quite frankly, laws that we ought to, we should get rid of. Repeal, yeah. Yes, at the earliest point. And when we talk about sexual offences in particular, and some of the things that we are calling on Parliament to act upon in terms of greater protection for our men and boys when it comes to rape and so on, some of those calls from JFJ and other groups certainly will be amplified. But as the country pursues its constitutional reform agenda, I hope that the constitutional items certainly that will be discussed for repeal is, abortion areas, again, buggery, and so on. So, yes, on to the topic in the second half of the program. Let us start by saying that this week, Jade listeners, it has been heavily focused on the Integrity Commission and its handling of a matter that involved the Prime Minister. But that's one half of it, because it started from a report that was tabled in Parliament, I believe on February 14th, while some of you were celebrating Valentine's Day. Yes? That was last week, Tuesday.
Yes.
A report was tabled by the Director of Investigation, by the Commission, the investigators' report, that had some allegations in it, if you will, to say that the Prime Minister of Jamaica, the Honorable Andrew Holness, when he was Minister of Education, he apparently made recommendations for some contracts. At that time, apparently, it was nearing the Christmas period, according to the Prime Minister, and they needed to move with haste to ensure that people were paid timely. The Prime Minister said that at the time, when he was Minister of Education, he made a recommendation for a particular company to be considered and I want to use my words carefully here, to be considered for engagement. And it involves other state agencies as well. The report from the Director of Investigation indicated that the company at the center of this all, Westcon Construction, apparently the principal is a close colleague of the Prime Minister and business associate. So the areas of conflict of interest were flagged. And the Director of Investigation, in his report, which was submitted to Parliament on the 14th, submitted and tabled, would have asked the Director of Corruption Prosecution, which sits within the Integrity Commission, whether or not charges could be proffered against the Prime Minister and the other state agents
I think
that
even,
were involved.
Even the some more pointed language would be he would have given the report to that to that director for the director to make the decision. So he would not have even been able to have a direct recommendation to the director.
And as you said that, Jade, I want to use a few minutes to explain the construct of the Integrity Commission, because I think it's important.
Yes.
Because reason must prevail in our criticism, because certainly the Integrity Commission is not infallible at all, and they ought to be subjected to scrutiny. But let us look at it. You have an Integrity Commission that is governed by 5 eminently qualified individuals, and they provide strategic oversight of the activities of the Commission. It involves 2 retired justices. One is at the Supreme Court level or at the Court of Appeal. In that regard, it is currently chaired by Justice Seymour Panton. It includes, thirdly, the Auditor General. Fourthly, a retired public official with expertise in public administration, accounts, or another area that I can't remember at the moment. And lastly, a non-profit organization representative, 5 commissioners. The commissioners provide direct oversight to 4 statutory divisions. And I say statutory, in other words, the Integrity Commission Act outlines that these are the divisions, or any other divisions as the commissioners see fit can be established. So 1, you have the division of the corruption prosecution. 2, information and complaints. This is where the statutory filings are submitted. Thirdly, you have the direct division of investigation. And fourthly, you have, I mentioned corruption prevention is the 4th one. So in other words, how do you know what is a corrupt act and what do you do to prevent it? Then the commissioner oversee the executive director. So I want to be very clear here, and I hope the listeners are really paying attention. The executive director provides oversight of the day-to-day functioning of the Integrity Commission under the guidance and direction of the commissioners. The executive director provides no direct oversight of the 4 statutory divisions because, as I said earlier, these 4 divisions directly report or they act under the guidance of the 5 commissioners. The executive director, he provides currently oversight of the operational divisions of the Integrity Commission. So accounts, communications, and so on. Then the executive director comes in.
I don't know, Mikhail, that sounds all like not things having to do with the substantive work of the commission in terms of investigation.
Not at all. So to point out now, each director of those divisions, they act independent of each other. I want to make special note of the Director of Corruption Prosecution, who, interestingly enough, actually acts on no other authority because that position is conferred with the powers that are granted to the Director of Public Prosecution per Section 94 of the Constitution. The only time the Director of Corruption Prosecution may have his or her views reviewed is if said position goes to the DPP and say, when I'm initiating this decision whether to prosecute, can you look at it? Or the commissioner, or the commission rather, let me use correct language, may say to the DCP, can you ask the DPP to review prior to initiation? The DPP, as the constitutional authority for prosecution, can decide that I don't want this prosecution to continue. These are the powers of the DPP. But otherwise, the Director of Corruption Prosecution under the Integrity Action is under no authority. So this view that somehow Mr. Greg Christie was there reviewing the content of the Director of Investigation's report and then somehow influencing the position of the Director of Corruption Prosecution, it ought to be rejected. Because again, as we outlined earlier, the Integrity Commission may have acted in a way that we do not agree with. There may be differences of opinion, but we cannot put malice to the decision that was taken. And Jade, you know, as Deon Jackson Miller did last night with our board chair in explaining what malice means, can you just explain to our listeners what exactly that entails?
Okay, sure. So I actually looked up a definition and I got it from one of our learned Caribbean scholars, actually, Professor Gilbert Codolini, one of my professors from UWI as well.
Oh.
Yes. And he would have stated that when referring to malice, it has to refer to a motive other than a sense of duty to publish the material that is being complained of. And in essence, it amounts to making use of this occasion, so the publishing of the material being the occasion, for an improper purpose.
So in other words, this view that some of us have, that somehow these 5 commissioners and the executive director and the Director of Investigation and the Director of Corruption Prosecution somehow came together.
It would be quite a coordinated effort.
I mean, we have to be careful. We have to really be careful. And before we even get into the substantive discussion, Jade, around how the Integrity Commission may have acted, one of the things we noted, there was a press release from the 13 government senators saying that basically raising some concerns, and they asked some questions that I think that they're fairly reasonable questions. So they asked, for example, why did the commission fail to deliver the ruling of the report tabled at the same time? And the ruling here is the ruling from the Director of Corruption Prosecution at the same time as the report from the investigation division. And that's a reasonable question to ask. The Integrity Commission, however, said, and I think this is the biggest irony of it all here, is that Section 53(3) of the Integrity Commission Act, which is commonly referred to as the gag clause, prevented them from speaking publicly on the matter. Former Bruce Golding, Prime Minister Bruce Golding, the Honorable Bruce Golding, who is also on Bridge 99 FM,
yes,
in an article in the Sunday Observer, called the statement from the Integrity Commission hogwash.
Yes,
is the language that the Honorable former PM used. And I found it interesting. And I just want to read something from this article. Prime Minister, or former, the 8th Prime Minister said, the Integrity Commission is mandated to police and pronounce on the conduct of public officials and, where necessary, to initiate prosecution of offences of corruption. The mandate demands that it acts with absolute probity and impartiality, and we agree. But I think on the other side of the break, Jade, we can discuss whether or not we agree with the position of the Integrity Commission. All right, welcome back to Let's Start Justice. We're discussing the matter of the Integrity Commission and the handling of the commissioners, if you will, or the body, when it came to the matter involving the report, which indicated that or suggested that the Prime Minister may have acted improperly where conflict of interest matters are concerned. And then tied to that is, I almost said exoneration, but that's another conversation for debate, around the Director of Corruption Prosecution report, which followed thereafter. So for those who are listening in, just to quickly summarize again, the matter here is that there was a report that was finalized from last year, October, I believe, off the top of my head. Several weeks would have passed, but that report was submitted to Parliament and tabled on February 14th. Apparently, the Director of Corruption Prosecution would have ruled that there were not sufficient evidence or reason enough, based on the time that had passed and so on, and other matters, for a charge to be proffered against the Prime Minister. And that particular report was apparently submitted to the Commission from the DCP for 1 month now, but 2 days after was when Parliament got the Director of Corruption Prosecution's ruling. And that is the concern that people had. One, why did it take so long for the first report to have been tabled? I think perhaps it's a good thing, because you would have had a couple of months there with these allegations against the Prime Minister. But importantly, why did the ruling not be submitted with the Director of Investigations report on the 14th? And the commissioners cited the gag clause in their press release as one of the significant reasoning for them not submitting the two reports at the same time. So there is the press release. Jada was asking what your opinion on it.
Okay, so what the Director of Corruption Prosecution said, let me just read a little bit from the release. They said, in the matter where a report has been sent to Parliament, cannot be communicated to anyone before the report has been tabled. This is so by virtue of Section 53(3) of
So that's the Commissioner said that, yeah.
Yes, of the Integrity Commission Act, which states that until the tabling of a report in Parliament, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of the investigation. In the instant case, this is also continuing from the release. In the instant case, the report having been sent to the Director of Corruption Prosecution as required by law, she submitted her ruling on the 12th of January 2023 to the Commission. The Commissioners, not having had the opportunity to read and understand and discuss it, took the time to do so. So I think what you're really asking me about is would the gag clause apply here? I think one of the issues that we have flagged, not just ourselves, but many other agencies when the review of the Integrity Commission Act came up last year, is that this section causes too many problems to remain as it is. The interpretation of the section is a constant challenge. During the presentations that would have been made to Parliament, several of the members of that committee would have, and I think in particular, Member Malahoo Fort would have made it clear that it is not the Parliament's opinion that Section 53 is a hindrance to the conduct of investigation or the release of information.
And this particular instance, she clearly outlined that she believed that the interpretation of the commissioners in this regard is flawed.
Yes.
And she believes, as others share her beliefs and opinions, that it is not in keeping with the spirit or the intention of Parliament.
Right. I think that considering the seriousness of the kinds of investigations that are undertaken by the Commission and even the possibility for misunderstandings like this, because what we are being told is that the Commission has misunderstood what their powers are under Section 53(3) and that both reports could have been tabled simultaneously.
And Minister Malahoo Fort in another radio interview made note that even if the Commission did not believe that the gag clause could allow them or did not prevent them from speaking, then Section 36, I think, subsection 3 allows for special reports. One of those sections allows for special reports.
Special reports that can be tabled.
But remember, the Commission has spoken before that they do not believe and share that view, another attorney's view. But what is important here is that it comes down to an interpretation of the Act. And I think, and I really urge Parliament to fix the issue.
Yes.
There's another issue, though, is that the executive director, I follow him, and he does tweet daily on all issues surrounding corruption that perhaps he believes, things that may be not speaking favorably about the Commission and so on. He would retweet them. My position, however, is that the executive director should have been a little bit more circumspect about tweeting that particular article, given he would have had prior knowledge. However, I'm not sure that it rises to the level of calling for a resignation. That is where I stand. I think he should have been circumspect, sure, but I'm not sure it rises to that level at all at this time. And I think the call from the 13 government senators asking certain questions, I asked the government senators, though, and other members of government, why do you not utilize the oversight committee that exists?
Yes.
That is chaired by member Edmund Bartlett.
Yes.
Why not use that oversight committee to ask the commissioners to come before Parliament, answer these questions, rather than furthering things that perhaps can undermine the integrity commission? And that's the problem I have.
So for those persons who don't know, what is this oversight committee?
The oversight committee is established through the standing orders, I believe. And it basically says that there's a bipartisan committee of the Parliament that exists to ask the Commission to basically monitors the function of the Integrity Commission. And when the reports are submitted from the commissioners, it goes to the Oversight Committee. So that is where the Integrity Commission in the past have said that I need the gag clause to be removed. I need a stronger anti-corruption framework. And to be fair to Parliament, the Integrity Commission Act is currently under review through the Joint Select Committee. But, my whole position, Jade, is that there are several things that must be done. The gag clause, I think it's time for it to be removed, because when you listen to the radio programs, you hear people asking the question, so wait, the Prime Minister not having his statutory declarations certified, is it because of Greg Christie? Is it because of Justice Panton? So the inability of the Commission to speak is actually, in my opinion, what is also causing the integrity
negative perception of the persons the integrity
because
commission
there are
holds.
guidelines that we have asked to be considered. So nobody's saying that the integrity commission should be able to go and just speak whatever they feel like speaking. Not at all.
Not
because persons' reputation must be safeguarded, certainly. And as we said in Parliament, the parliamentarians must consider whether or not it is in their belief that their reputation is somewhat more important than the average man and woman on the ground that the JCF can name as persons of interest and wanted people and flyers. They have to ask themselves how the law is being applied equally.
Yes.
So I don't share that view at all. But I think the Integrity Commission, I think they should have called a press conference at the very least. That is what I would agree with my colleagues on. But it's a slippery slope to be going down to be talking about the Integrity Commission is acting out of malice. And again, I ask the question, why is there naming of the executive director?
I think
for the most part, vilifying the executive director when the structure is very clear.
I think we also have to be careful. Well, our parliamentarians or government officials have to be careful as to how they criticize what is the major anti-corruption body in the country, and how undermining the work of that body can serve to affect our confidence in their work as
and they should also follow
here.
What they're saying the Integrity Commission should do.
Yes.
Rather than speaking via press releases, why not go to Parliament, convene the Oversight Committee, and then ask the Integrity Commission to answer the questions? Why are public officials in the news that may unwittingly and unintentionally undermine the Integrity Commission when it may very well come down to a matter of interpretation?
Yes.
I think that is my challenge with all that is happening here.
Yes, I agree that the use of the Oversight Committee would help to, one, clarify some of these issues, and two, maintain confidence on both sides that this is a transparent process that is being executed in the correct manner.
They only met twice in 2021 based on the Integrity Commission's annual report. So I would urge the Oversight Committee, please meet more frequently, at least quarterly, as you provide monitoring oversight of the Integrity Commission. It's important. All right, so that is it for today. Any last words, Jade?
Yes, I'd like to say our producer is playing the outro music in our ear. He's letting us know it's
I think Sean is saying you need to get up now and go.
Absolutely.
But thank you so much to the Bridge team, as always, for facilitating us on the program here. We appreciate it.
Yes, this has been Let's Start Justice. You can join us again next week at the same time, Tuesday, 1 p.m. I was Jade Williams.
And I'm Michael Jackson. Have a good week.